Yes.
Bless your lordships. Your lordship, I'd like to mention item 32.
32. Yes.
I agree for 3 weeks time, your lordship. I'm representing all the state respondents here.
Okay. For filing of your counter affidavit or what?
For the counter, yes.
Okay. Mr. So and so, learned senior government advocate, has prayed for further time for filing of his counter affidavit for the state respondents. Where is allowed? List after 3 weeks.
True.
Please, Lordship. Lordship, I'd like to mention item number 33 and 34.
Yes.
Lordship, I pray that I may be granted 3 weeks' time to file my affidavit in reply, filed by the state.
Miss
And Rapero.
N. Rupero, learned counsel for the petitioner, has prayed for 3 weeks' time to file her reply to the counter affidavit filed by the state respondents. Accordingly, list after 3 weeks.
Yes, Lordship.
Your Lordship, here, the item number 35 to 54, these are analogous matters. Here, the pleadings are complete. But since these matters are similar in nature, this may be listed together, Your Lordship, after 3 weeks.
Who is appearing for the petitioner? No, here for 33 and 34, isn't it? Now,
Lordship.
35 is also
Yes,
similar?
Yes, 35 to 54, Your Lordship. But the
Okay, now this is different. 35 to 54, yes. Pleadings are complete. Is it who's for the counsel for the petitioner? Are pleadings actually completed?
35 to 54.
No.
Lordship, here.
Yes, 35 to 54.
Pleadings are completed.
Both of you agree, okay? Yes, okay. The learned counsels for both the parties submit that pleadings are complete and that this matter may be listed for hearing. Accordingly, list after 3 weeks for admission hearing.
Yes, along with the earlier matter which you mentioned, 33 and 34.
No, 33 and 34, she has paid for time for filing of reply. So
Yes, that's
pleadings,
why, Your Lordship, it may be listed together, Your Lordship.
then pleadings are not completed
Oh,
yet.
Your Lordship, it's all like that. Your
No, it
Lordship,
cannot
yes.
be because they're still waiting. Yes. So after 3 weeks, anything else?
No, Lordship.
Your Lordship, I also beg to mention item 55, Your Lordship. Here the state is yet to file counter, so kindly grant 3 weeks time.
Miss
In a holy, Your Lordship.
Lena Hawley, learned government advocate for the state respondents, have prayed for time for filing of their counter affidavit. Praise allowed. List after 3 weeks.
Much obliged. Your Lordship, I also beg to mention item 29 and 30 on behalf of my colleague Livika. Here, Your Lordship, she has filed her counter affidavit, but with regard to the implement of new respondent, she's yet to file. So kindly grant 3 weeks time, Your Lordship.
Okay. Mention is made on behalf of Miss Litika so-and-so, learned government advocate for the respondent, for the state respondents, that time may be granted to file counter affidavit in respect of the newly impleted respondent number 6. Accordingly, list this matter after 3 weeks.
Much obliged, Your Lordship.
May I please the Lordship? Lordship, I'd like to mention item number 6 and 7, Lordship, for the state respondent. Lordship, I am allowed 3 weeks' time to file my affidavit, Lordship.
Okay, Mr. So-and-so, learned government advocate, has prayed for further time for filing of the counter affidavit. Prayers allowed, list after 3 weeks.
Your Lordship, there is interim.
Meanwhile, as prayed for by the learned counsel for the petitioner, interim order passed earlier shall continue till the next date. You want your name to be reflected? As prayed for by Miss
T. Atale Chisel.
T. Atale, learned counsel for the petitioner. Okay. Interim order passed earlier shall continue. Yes.
Please, Your Lordship. I beg to mention item number 4 and 5, Lordship. Kindly grant 2 weeks time to file and I reply to the affidavit in opposition filed by respondent 5 and 7, 5 to 7.
Okay. Miss
Viketsono.
Wicked Jono, learned counsel for the petitioner, has prayed for time.
Lordship, I'm agreeing for respondent number 9. Here, we have already filed a rejoinder to the reply filed by the petitioner today. So,
Okay.
hearings are completed. Let him come up for admission.
No, she wants time to file a reply. Okay. So, Ms. So-and-so, learned counsel for the petitioner, has paid for time for filing of the reply to the counter affidavit filed by respondents number 5
5 to 7.
to 7. Then, Miss, yes, your good name, respondent number 9. Miss Pamini, learned counsel for respondent number 9, submits that they have filed their counter affidavit today.
Rejoinder to the
Rejoinder counter is the same. Okay, counter affidavit today itself. Yes.
No, the state has already filed.
Okay. The state is respondents is duly represented by Miss So and so, learned government advocate. In view of the above, list the matter after 3 weeks.
Lordship, I have similar prayer for item number 8 to 28 to find my reply to the respondent number 5.
8 to 28.
Yes,
Okay,
Lordship.
yes. Miss So and so has prayed for time for filing of their reply to the counter affidavit filed by the state respondents. Accordingly, list this matter after 3
3 weeks,
weeks.
Lordship.
Sorry for the interruption, my lord. Lordship, there was an interim in item number 29, which was mentioned earlier. So you may please continue.
On the prayer made by the learned counsel for the petitioner, interim order passed earlier shall continue till the next date. Yes, 29. Yeah?
Last one.
For motion, item number 1.
My lord, in filing the review, there is a delay of 116 days. So I filed a IA for confirmation of delay.
Okay. Your main reason is what? Why have you delayed in 100 and something days? What is the-
16 days.
Ah. What is the main reason in one or two sentence, just a gist as to why was there a delay?
My lord, the delay was mainly because of the communication gap.
Okay. Communication gap between the council or what? Between whom? The petitioner, the applicant and the? You have filed the IA, you should be knowing why there was a
My
delay.
lord, paragraph 4.
Okay.
Yes. I obtained CTC only on 23/5/2023. And it was communicated through one messenger, the lady of the petitioner is Kohima.
Because the petitioner resides in a village known as Pongching.
Yes.
This is which is quite far off.
It's,
it?
It's not that far actually, but the communication is so bad.
Okay.
Road communication.
Will issue notice.
My lord.
Heard Mr. Imti Longcha.
I empty.
Imti Longcha, learned counsel for the applicant slash petitioner, who has filed this application for the condonation of a delay of 116 days in filing the review petition against this court's order dated 2804 2023, past 10, WPC number 61 of 2019. Under Section 5 of the Limitation Act, 1963. Issue notice to the respondents. Mr. So-and-so, learned government advocate, accepts notice on behalf of the state respondents.
Lordship, 1 to 8 and 10.
Okay.
9 is accountant general.
Okay, on
Yes.
behalf of the state respondents,
1 to 8
1 to 8
and 10.
and 10. Notice is to be no need to issue formal notice. Notice is, however, to be issued to respondent number 9 through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks.
Much obliged.
Obliged.
For motion, item number 2.
Yeah, please, Your Lordship.
Yes.
Lordship, the petitioner's father, he was serving as a UTA in the Department of Nagaland State Transport, Nagaland, during the time of his demise. He expired on 16th of April 2019. Your Honor, the death certificate is enclosed at page number 19, Annexure 3. Thereafter, immediately after the passing of the petitioner's father, the petitioner filed an application to consider her case on compulsion ground, which is at page number 22. By enclosing all of the necessary education qualifications stating the reasons. Lordship, thereafter, in the same month, if you could kindly turn to page number 31, Annexure 6. This is by the Assistant GM, Lordship, to the GM, General Manager Nagaland, where he has stated the forwarding of, in the subject as forwarding of application. I have the honor to forward here with the application of Ms. That is the petitioner, daughter of so-and-so, under parent district, for your kind consideration and necessary action. So the application of the petitioner was forwarded by the assistant GM to the GM, Lordship. Thereafter, there was no response. That was in the year 2019. Therefore, the petitioner, she filed an RTI, which is at page number 22. Your Honor, if you could kindly turn to pair number 2.
Yes.
That she stated the reason to furnish the names of and date of application received and the date of appointments of employees appointed on compulsion grounds, specify the vacancy post against which the applicant was appointed. Your Honor, if you could kindly turn to the next page, 32, Annexure 7.3. In query number 2, they have said the answer is nil, which means from 2019 till that or before that also, no person was appointed on compulsion ground. And Your Honor, if you could kindly turn to the next page, that is page 34. This is the continuation of the same reply. Query number 1, details of the employees died in harness with effect from 2010 till date. Your Honor, here the name of the petitioner's name is missing. Secondly, query number 3, details of application received on compulsion ground with effect from 2000 till date. Here the name of the petitioner is missing. Name of the petitioner's father's name is also missing. The petitioner's name also is missing in the list who has applied for compulsion appointment. Lordship, thereafter, this was in the year 2019. Thereafter, if you could kindly turn to the next page, 35, Annexure 8. Again, another RTI was furnished. In the meantime, communication was made to the respondents to consider case. Since there was no response, again another RTI was filed, page number 35. Here, Your Honor, if you could kindly turn to page 37. This is the reply. Your Honor, you will find that from serial number 44 to 48, 49, 53, 67, 74, 91, 95, 97. Thereafter, from 103 to 111. Your Honor, there were 22 LDAs, that is correctory posts, who were appointed after the petitioner had filed her application. And if you could kindly see on the right-hand side, the mode of appointment is government approval. Your Honor, these are all appointed through backdrop, not through NPAC, not through any open advertisement. But the case of the petitioner was never considered here, and not only the petitioner, but none of the appointments were met on compulsion ground. Your Honor. If you could kindly turn to the next page, that is page number 40. You will find here, if I may read the order, this was passed in the year 2019. This is about 3 months after the petition has expired and after the application, petition file application. Here you will find that Srimati so-and-so is hereby appointed temporarily as proportion to the post of LDA CAM assistant so-and-so against the vacancy of late so-and-so. This is the name of the petitioner's father. Petitioner's case was never considered, but immediately, urgently, the respondent, they appointed someone else against the vacancy created by the death of the petitioner's father. Lordship, my prayer is that if you could kindly turn to the next page, 41, and
yes.
this is the office memorandum.
Concerning compassionate appointments, yes.
Here, paragraph 2.
Is there some quota here concerning compassionate appointment from the vacancy available? Is there some system here in the government of Nagaland where for compassionate appointment, a certain quota percentage has been kept aside?
Yes,
Is there?
Yes.
Okay,
If
let's
you could
see.
kindly turn to page number, paragraph 4. Same order. Compassionate appointment may be made to the post falling under the combined direct recruitment quota of Group C and D. The ceiling for compassionate appointment of 5% of the direct recruitment vacancies in Group C and D posts has been done away with, provided such appointments do not exceed 50% of the vacancies during a year. So, Lordship.
So it's quite liberal here.
Yes,
is it?
50%. And it has to be reserved for compassionate appointment from the total vacant post. The appointment against the post for direct recruitment in Group C should be in the entry grade only. Further, the appointment against any post for direct recruitment in Group C should be limited to those posts which are outside the purview of NPSC for recruitment. So here the policy, the memorandum is very clear. 50% of the total vacant posts in a year, it has to be through compassionate appointment only. Your Honor, but the case, even about reminding also, it was never considered. Your Honor, at page number 43. Since her case was never considered, representation was sent to the GM, one of the respondents. Here, again, at page number 42, continuation, if I may read, the undersigned also beg to state that the RTI application was filed on so-and-so before your good office, seeking information pertaining to employees died in harness with effect from 2010 till date. An application received by the department for appointment on compassionate ground with effect from 2010 till date. However, in the reply, the nature of the undersigned was not reflected, nor the name of the deceased employee. Father of the undersigned could be seen in the lease maintained and replied by the department. So it was intimate. This was filed this year in the month of March, Lordship. But till now, no reply. We have stated very clearly that the petitioner's father's name is also missing and my application is also missing. But my prayer has never been considered. Your Honor, at page 45, this is very important. Annexion number 12, the last page, the last annexion.
Yes.
Your Honor, if I may kindly read para 1. Compassionate appointment made to Group C and D posts under this scheme shall be strictly in order of date of death. And first preference shall always be given against those who have died earlier and who fulfills all eligibility criteria. Your Honor, as per the addendum, if you go by this, because it says that the first preference, the serial number should be maintained chronologically from the date of death, which means I should be at serial number 1. Because as per the RTI reply, which I have enclosed here, at page number 34. This is the first reply that they have given. Given the date of application received was only in the month of September, whereas I have submitted my application in the month of in the month of April itself, the same year. Therefore, my prayer is that Lordship, notice may be issued against the state respondents, and the name of the petitioner's father may be included. And I may be given my at serial number 1, and then I may be appointed. And lastly, I may be appointed in any grade 3 post on compassionate ground.
Yes, okay. Heard, Mr.
Limatushi.
Limatushi, learned counsel for the petitioner, who submits that this writ petition filed under Article 226 of the Constitution is for passing the appropriate writ against the respondents for the appointment of the petitioner on compassionate grounds on the death of the petitioner's father, late I.
Lanuchuba.
Lanuchuba Au, who died while serving as UDA in Perin district under Nagaland State Transport Department on 16/04/2019 at Dimapur, Nagaland, after a prolonged illness. Full stop. The learned counsel for the petitioner submits that the petitioner had submitted an application to the respondents for appointment on compassionate ground. However, the petitioner came to learn through an RTI application dated 17/10/2022 that the petitioner's father, the name of the petitioner's father in the list of employees who died in harness was not included, and that the petitioner's application for appointment on compassionate ground was also not included in the list so prepared by the state respondents. He further submits that in spite of their pending application for appointment on compassionate grounds, the petitioner learned through RTI application that other persons.
22 LD.
Pardon?
22 LDs were appointed.
Okay, 22
Page number 37.
LD.
No, this is grade 3 post. LD.
Okay, 22 is it?
Yes, Lordship.
22 LDs were appointed, and the petitioner has not been considered in the appointment. On hearing the submissions made by the learned counsel for the petitioner, this court finds it fit to issue notice of motion upon the state respondents. Miss So-and-so accepts notice on behalf of the state respondents.
1 to 4, Your Lordship.
The respondents, state respondents 1 to 4. How many respondents are there?
4 respondents only, state respondents.
Yes. No need to issue any formal notice. List, a copy of the writ petition is accordingly to be served upon the state respondents. List after 3 weeks.
4 weeks, Your Lordship.
Okay, list the matter after 4 weeks.
Much obliged, Your Lordship.
Much obliged.
Yes.
For admission, item number 3.
Please, Lordship, my ladyship, the counsel for the opposite parties, they are on foot in the court number 2. This is pertaining to non-payment of contract bills, which the petitioners has executed to work. It's an admitted bill, but they are, and then the state respondents, the ministry, they are shifting the burdens to upon each other, saying that it is the liability of the state to pay, and whereas the ministry is saying that it is the state that has to pay.
Okay, so in the last court's date, it is mentioned that the learned counsel for the
Yes.
petition, he may be granted 1 week's time
Yes.
to obtain instructions.
Yes.
So what instruction did you obtain?
In a similar case, where the funding was stopped by the ministry, that scheme must be revived.
So
only-
that's the instruction which you wanted?
Yes, I
had to
wanted to
obtain.
copy of the order. That's why I have asked for some time to obtain the copy of that order, which was passed in WBC 2228 of 2022. the simile issue where funding was stopped, and then on the request of the Council for the CGC, the scheme was revived only for that particular work.
Okay. So most probably you'll have to give a copy of that also to the respondents.
Yes.
No? So we'll reflect this thing which you're going to, the what? The instructions which you had obtained. That is the
Yes.
instruction you obtained. So we'll make that a part of the file,
Yes.
isn't it? Now, do we have to wait for the CGC?
It's
And then
okay,
we can
I'll finish the
reference.
copy.
Yes, okay, yes, you are
And
appearing.
They are fully aware of, because
Okay.
he was the same person.
Then after, in the next date, we can see what can be done. Let's see, what is it about? This is a copy of the judgment or this thing, an order of this court.
Yes, this is out of this court.
So you're saying this is a covered matter or what?
Similar issue, so a similar direction may be issued. Or the matter can be settled between the state and the ministry. Who will pay?
Anyway, heard Mr.
And Kohima,
N.
my ladyship.
Long Kumar, learned counsel for the petitioner, who submits that he may be allowed to bring to the notice of this court the order passed by a coordinate bench in WPC 228/2022, which is also with regards to what? Non-payment?
Yes, non-payment.
Non-payment of bills to the petitioner in the said WPC. He prays that since the matter is similar, the respondents may pay the dues entitled to the petitioner as per entitled to the petitioner in line with the judgment WPC 228/2022, and prays that the respondents may settle the matter as per the judgment passed by the coordinate bench. Is it correct, your submission? I'm not very listening. Yes, Miss
Asikiri for Mr. Gauhati CJC.
Secretary makes appearance on behalf of Mr. Yangarwati, learned CGC, and submits that she may be given time to get instructions. Copy of the WPC /228/2022 is to be furnished to the learned counsel appearing on behalf of the learned CGC for respondent number 5. Is it? Now, who is for the state to this thing?
And
State resp- So you're saying that this case is with respects to who is going to pay the money, is it?
yes.
I think I cannot listen to only you. I need to listen to the respondents also. So today we'll simply say copy will be
Yes.
given. Okay, and then you see we'll list after 1 week. List this matter after 1 week.
Blush, my ladyship.
For admission, item number 31. Item number 31.
Yes.
Yes, Your Lordship. Your Lordship, we have instruction to appear for respondent number 3, so kindly grant us 3 weeks.
Okay. Miss,
Asikire, on behalf of Mr. Yangawati.
okay, Asikeri, appearing on behalf of Mr. Yangewati, Lanit CGC, submits that they will be appearing for respondent number
3.
3 and has prayed for time for filing of the counter affidavit. Mr.
Chingmai.
Chikmai appears on behalf of the petitioners. This matter after 3 weeks.
Pledge.
For admission, item number 56.
Oh, this is the part heard matter where you're supposed to give a copy of the judgment, isn't it? Some ruling, he says you want to submit in the court. Who had mentioned that? I think we've heard the matter. Only there was a ruling which the learned counsel for respondent number 5. You're the one?
Yes, Lordship.
Yes. Okay, anything else? We'll make it a time being matter. If you're not ready, we'll make it a time being.
Okay, Lordship.
For admission, item number 57.
May I please, Lordship? My Lord, here the petitioner is praying for disposal of the representation dated 13/10/2022. There are 2 representations, one submitted to the Commissioner Nagaland and the other representation submitted to the Chief Secretary Nagaland. So if an order may be passed directing the respondent to pass necessary order.
Okay, where is the
By
representation?
disposing my representation. My representation is at Annexure C and D. Annexure C and D, which is at page number 17. Starts from page number 17. This is the representation submitted to the Chief Secretary Nagaland.
Okay, what is the nature of your representation?
Here, my Lord, the petitioner, he is the then Deputy Commissioner Nauklak. While he was serving as the Deputy Commissioner Nauklak, he received a trade call. And to that effect, he has made a complaint for necessary investigation. Then, in the process, again, another FIR was filed against him on the ground of molestation. So, in that case, when the matter was still pending, the petitioner filed one writ petition, transfer petition, one transfer petition before this honorable court. And in that transfer petition, when the state respondents filed their affidavit, they have stated things which were not factually correct, and the complaint that he has filed was also closed without his knowledge. So basing on all these, and the state respondents by filing their affidavit in opposition has started passing negative comments on the petitioner and also questioned the personal integrity of the then Deputy Commissioner. That is how, basing on that, he has made these 2 representations to the Commissioner Nagaland and the Chief Secretary Nagaland, questioning as to whether all these statements was made before the court with their consent or with their knowledge or not. So that basically that is the question made before the 2 questioning the 2 representation. So if direction may be given to the respondent to dispose of my representation in a
Okay, I think we can do that.
appropriate time, my prayer will suffice.
Isn't it? What do you have to say for the state? Nothing?
Lordship, this is a matter pertaining to the IS officer. then ultimately that will be likely to be affected on the service matter, where the estate has no hand at all. So we are taking all the appropriate steps, but it takes time. So in such a case, Your Lordship, sufficient time will be given to the estate respondent so as to dispose of the representation of the
Okay,
petition.
so,
My representation was submitted almost a year ago. Almost a year ago. So if the direction will be given to dispose within 2-3 weeks, because I submitted on 13th of October 2022. Now it's almost 13th October 2023. So almost a year ago.
yes, so how much time will
2
you
weeks,
take?
Madam.
2 weeks, can you do it?
Your Lordship, 2 weeks will be too short.
Uh,
I mean, we are allowed to
4 weeks.
4
3
weeks?
months.
No, my lord. To dispose the representation, they are taking more than a year.
Oh, yes, but this is concerning an IAS officer. I
Yes.
think you'll have to,
I have to take a precaution at home. I have to, hastily, I cannot take up any steps. So 3 months will be enough for
3
us.
months, 3
No, my
months?
lord,
Okay, we'll make it 2 months. Within 2 months, see if you can expedite the matter. I
But
think.
the question that was raised in my representations, it is very simple, my lord. It is very simple. As to whether any investigation has been done, as to whether it is in their knowledge, by making all those statements before the Honorable High Court, whether it is in their knowledge or not, that's simple questions.
Okay, anyway, heard Mr. Ezo, is it?
No,
Learned
Takakichu.
Counsel. Oh, Takakichu. I'm looking at the last order. Okay, Mr. Takakichu, Learned Counsel for the petitioner, along with Mr. Imti Imsong, Learned Additional AG for the state respondents. The Learned Counsel for the petitioner submits that this writ petition may be disposed of with a direction to the state respondents to dispose of the representations submitted by the petitioner to the state respondents dated
13/10/2022.
13/10/2022 and 13.
On the same day, my lord.
Okay.
13/10/2022.
Then make it the two representations submitted on 13/10/2022. But what is the representation about? Which is for the state respondents. What did you say in your representation, which is at least a subject?
If my lord may kindly come to page number 18.
18.
Page
Yes.
number 18. Page number 18. The last paragraph, 5, and
Yes.
below that 5, clause 1. Whether an inquiry
Okay.
has been conducted to verify the facts mentioned in the letters before the submission to the court, that they
Yes.
are malified copy of inquiry. This 1, 2, 3, 4, 5. These are the 5 questions.
Okay, so page 18, to respond to the queries made at page, okay, 1, 2, 3 up to 5. The Learned Additional AG has not objected to the disposal of the writ petition with a direction to the state respondents to reply to the representations made by the petitioner. He, however, submits that since the petitioner is an IAS officer, he may be granted ample time for the state respondents to reply to the petition, to the representations so submitted. Having heard the submissions made by both the parties, considering the limited nature of the prayer made by the learned counsel for the petitioner, this court finds it fit to dispose of the instant writ petition with a direction to the state respondents to reply, to consider and reply the representations submitted by the petitioner dated so and so within.
Your Lordship, since the petitioner has been patient enough, so a last chance may be given for 3 months. It's very for in terms of weeks.
My lord, in that case, let it be 1 month, my lord.
Okay, within
Considering
1
the
month,
fact that, considering the fact
Your
that
Worship,
it is
within 2
written
months.
again.
You are saying you are praying for 3 months. You're praying for 3 months. He's praying for 1 month. So we'll make it 2 months. Okay,
Well.
within 2 months. With a speaking order. Accordingly, so writ petition so and so stands disposed of with the above direction. Yes. Yes.
Much obliged.
For admission, item number 58.
My lord, here also, I'm praying for disposal of the representation. My lord, initially the petitioner filed a writ petition on the ground that his land that was acquired by the respondent was not surveyed. And during the process, this honorable court passed a direction to survey the land of the petitioner, and that is how the petitioner's land was surveyed. And the assessed compensation amount was submitted before this honorable court, and that is how the petitioner the writ petition was disposed. Then, after that, the petitioner has filed one representation as per section 18 of the Land Acquisition Act to the Deputy Commissioner for enhancement of the compensation amount. So if a direction may be issued to the respondent to dispose of the representation within a specific time.
Yes, where is your representation?
My representation is at page number 12. No, sorry, my lord. It starts from page 14, Annexure C, page 14. Page 14.
Yes. Anything?
Yes, Your Lordship. The leading counsel for the respondent number 6, NHIDCO, he's not there, so it may kindly be listed on Monday.
Let both the parties be present at least, isn't it?
In fact, I have submitted the representation to the Deputy Commissioner only. The NHIDCO, yes, of course, they are the sanction authority.
So they'll have to be there also, huh? Let the parties all be duly represented, then we'll dispose it off. In the absence of one party, it might not be very appropriate, isn't it? Mr. So-and-so, learned counsel for the petitioner is present along with Miss
Vitere.
Vitere, learned counsel for respondents number
6.
For respondent number 6. The learned counsel for the petitioner has prayed that the instant writ petition may be disposed of with a direction to the state respondents for disposing of the representation submitted by him on
14/4/2023.
14/4/2023. It is, however, seen that the respondents number 1 to 5, is it?
1 to 5.
Are not. Are you representing?
Yes, Your Lordship, I am representing 1 to 5.
Then who is?
Senior. Respondent number 6,
7.
senior.
Okay. 1 to 5 are represented by learned additional AG. So who is absent?
The leading counsel for the respondent number 6, Mr. Sandy Younger.
Okay, he's not around here.
He is on leg in court number 2.
Then I think we can dispose of this
But
matter.
this can be disposed of.
Yes,
Just
what
my
keep it
representation
pending?
is to the Deputy
Lordship,
Commissioner
actually,
only.
he's appearing for a very urgent matter today.
But his representation is to the deputy commissioner,
Yes.
that is the state, isn't it? At this stage. So I don't think it should really affect the matter. Okay, so we'll dispose it off. It's just the dispose.
Kindly give me a second. I'll go and call him.
Okay,
If I
okay.
may.
Yes, being very careful. That's a good sign. So respondents now, in this case, the respondents number 1 to
1 to 5 is the state respondent. and
state
number
was
6 is the
represented. And respondent number 6 is the, okay. So for the state respondents, the additional AG is there anyways,
Yes.
isn't it? So she's representing respondent number 6, is it? Yes.
My apologies.
No.
I was in court too.
Yes. So this is a simple matter where the counsel for the petitioner has prayed that it may be disposed of with the direction that the representation filed.
My lord, considering the limited prayer made by the petitioner,
Yes.
and also considering that the representation is not addressed to me,
Yes.
my lord, I have little to say. in
No,
this matter.
nothing to say. Okay, we'll dispose of accordingly. Disposed.
Much obliged.
Deeply obliged.
Your Lordship, here a time.
There's, yes, there's one time being matter also where I think you have to appear.
Your
The
Lordship,
time being
here-
matter?
Yeah.
In the present case,
Yeah, Your Worship, here, if at all, then the state respondent will have to take up the practical job survey. So 2 months maybe,
my lord.
Yeah, okay, 2 months,
2
2 months. Okay. I'll pass the order later, yes.
Much obliged.
For admission, item number 56.
Yes. Now, in the last court date, you had prayed that you may be allowed to?
Place some authorities,
Yes,
Your
one
Lordship.
authority.
But in the meantime, if my Lord may kindly allow me, may I rely on the prayer made by the petitioner in the petition and the appointment order before I place the authorities, if my Lord may kindly allow me.
Yes.
Page 7 of the petition, the petitioner's petition, the writ petition.
Yes.
Number 1, directing the state respondents to adhere to the agreement dated so and so and appoint a petitioner to the post of such and such under so and so office, Nagaland, on the strength of being one of the landowners. 2, the prayer 2 is further pray that the order dated so and so, the 31st March 2023, passed by the respondent be quashed and set aside. That is the appointment order of my client, the respondent number 5. Now, these are the 2 main prayers. Now, Your Lordship will see that no prayer has been made to strengthen and further extend the relaxation of the age relaxation period. As far as the age relaxation orders are concerned, it has expired with effect from 22nd April 2023. Now, until and unless that is strengthened, on what basis will the state appoint the, assuming, though not admitting, that this writ petition succeeds? On what strength will the petitioner be appointed when he has already become overaged? Number 2, if I may take Your Lordship to the Annexure D, page 25 of the writ petition. This is the appointment order of my client, the respondent number 5. May I read, Your Lordship?
Yes.
Order number so and so, consequent upon the approval of the government white letter number so and so, dated the 6th March 2023, Shri Swaya Vikul Tase is hereby appointed as animal attendant at VD CVO so and so. Now, Your Lordship will see here that the approval was given on 6th March 2023. Approval for appointment. Now here is a question, Your Lordship. The application submitted by the petitioner was received by the office on 9th of July 2021. 9 July 2021, when he was already 36 years of age. Now, Your Lordship will kindly appreciate this, that whenever applications have been processed, usually a vigilant petitioner, vigilant applicant follows and knows whether his or her name is also part of the list or not. Now, there is clearly the lack of vigilance on the part of the petitioner also for not knowing whether his name has been rejected. By the time he submitted his application, the Learned Government Council has said that when it was received on 9th of July 2021, the department decided to immediately reject his application for the fact that he was already 36 years of age. So vigilance, to be vigilant about one's right, is very important while approaching the Honorable Court to redress one's grievance, Your Lordship. That I do not need to elaborate. My Lord is fully aware of that. The petitioner has also not been vigilant, that his application has been rejected. He has not even challenged the approval order, 6 March 2023. And after everything is over, after the appointment was made, after the petitioner has joined the office, after the expiry of the period of relaxation of age, the petitioner chose to come before the Honorable Court. Your Lordship is aware that as far as the principle of law is concerned, exceptional relief to be woven in favor of the petitioner, no fault should be attributable to the candidate. He has to show extreme vigilance that he has taken all measures to see that there is no slackness on his part. And even the prayer of the petitioner has not asked for extension of the period of relaxation which has expired on 22nd April. Now, if this Honorable Court is to grant relief to the petitioner, in fact, my learned brother for the state respondent will also make his submission, but Lordship, it will set a wrong precedence. That is why I am going to place my reliance on some of the authorities.
Yes.
My Lord, the 2021 5 SCC, page 638. My Lord, I am relying on a few paragraphs, paragraph 38, 41, 43, 45, 46, and 47. May I read, Your Lordship?
What is the case about?
Oh, this case is about
Facts are slightly different.
the extension of age during the COVID period.
Okay.
May I read, Your Lordship?
Wait, I think they're giving the
2021 5 SCC, page 638. Paragraph 38 is from page 656. 656.
Yes.
May I read, Your Lordship?
Yes.
We do find substance in what is being urged by the Learned Counsel for the petitioners in their say in questioning the decision placed by the first respondent for our consideration. If an additional attempt remains, this is an attempt to appear in the UPSC exams and all, restricted to the last attemptees for the reason that they had suffered during COVID-19 pandemic, all attemptees, irrespective of the nature of attempt, the first, second, etc., who appeared in examination 2020, must have the same consequence as been faced by the read petitioners, and each one of them have suffered in one way or the other during COVID-19 pandemic. At the same time, this reasoning would equally apply to those who have crossed the upper age barrier. More so, when no discretion is left with the first respondent to grant relaxation in age bracket to the candidate other than provided under Rule 6 of the scheme of the 2020 rules. Now, this language, my lord, may kindly take note very seriously. When no discretion is left with the first respondent, the period is already over, your lordship, on that lines. When no discretion is left with the first respondent to grant relaxation in age bracket to the candidate other than provided under Rule 6 of the scheme of 2020, of right that apart, 2020 rules which indeed the present petitioners are not entitled to claim as a matter of right, and that apart, those who have withdrawn their form either because of lack of preparation or because of some personal reasons but have crossed the upper age limit to appear in CSC 2021, they would also be equally entitled to claim, and no distinction could be made whether the candidate has appeared in the examination of 2020 and availed the last attempt or attempts is still available at his disposal or has crossed the upper age limit. Then, your lordship may kindly come to para 41. 41.
Yes.
The submission in our view is without substance for the reason that the policy decisions which had been taken by the executive on earlier occasions, of which a reference has been made, always depends on the facts and circumstances at a given point of time and have to be tested independently in the circumstances in which it has been exercised by the competent authority or the first respondent, as in the instant case. That's up, this talk about discretion, your lordship. Then the paragraph 43. It is a settled principle of law that policy decisions are open for judicial review by this court limited purpose, and this court can interfere to the realm of public policy so framed if it is either absolutely capricious, totally arbitrary, and not informed of reasons, and has been considered by this court in the Union of India versus Selva Kumar. The relevant portion is under paragraph 47, which is reproduced. There is one more reason due to which we are unable to subscribe to the view taken by the Madras High Court and the Delhi High Court. The horizontal reservation and relaxation for physically handicapped category candidates for civil service examination is a matter of governmental policy, and the government, after considering the relevant materials, has extended relaxation and concessions to the physically handicapped candidates belonging to the reserved category as well as the general category. Now, this is the important part, your lordship. It is not in the domain of the court to embark upon an inquiry as to whether a particular public policy is wise and acceptable or whether better policy could be evolved. The court can only interfere if the policy framed is absolutely capricious and non-informed by the reasons or totally arbitrary, offending the basic requirement of Article 14 of the Constitution. An exception, your lordship. Then, para 45, your lordship.
Yes.
Judicial review of a policy decision and to issue mandamus to frame policy in a particular manner are absolutely different. It is within the realm of the executive to take a policy decision based on the prevailing circumstances for better administration and in meeting out the exigencies at the same time. It is not within the domain of the courts to legislate. The courts do interpret laws, and in such an interpretation, certain creative process is involved. The courts have the jurisdiction to declare the law as unconstitutional, that too, where it is called for. The court is called upon to consider the validity of a policy decision only when a challenge is made that such policy decision infringes fundamental rights guaranteed by the Constitution or any other statutory right. Merely because, as a matter of policy, if the first respondent has granted relaxation in the past for the reason that there was a change in the examination pattern, syllabus, and in the given situation had considered to be an impediment for the participant in the civil services examination, no assistance can be claimed by the petitioner in seeking mandamus to the first respondent to come up with a policy granting relaxation to the participants who had availed a final and last attempt of course the upper age limit in the examination 2020 as a matter of right. Now, Lordship, whether this Honorable Court can give a direction under the exercise under the writ of mandamus directing the petition, the state respondents to further extend the age period. Then your lordship kindly come to para 46. It has been brought to notice that only the petitioners, interveners before this court, but there are a large number of candidates who appeared in the various examinations in the year 2020 during COVID-19 pandemic, and everyone must have faced some constraints, impediments, inconvenience in one way or the other, and this court can take a judicial notice that these petitioners have appeared in the same pattern of examination in the previous years since the year 2015. And what is being claimed and prayed for under the guise of COVID-19 pandemic is nothing but a lame excuse in making additional attempt to participate in the civil services examination 2021 to be held in future. And we find no substance in either of the submissions which has been made before us. Then 47, your lordship. The data furnished to this court by the commission clearly indicate that various elections have been held by the commission for central services examination in the year 2020 during COVID-19. Selections must have been held by the state commission and other recruiting agencies. Now, this is the important part, your lordship. If this court shows indulgence to few who had participated in the examination 2020, it would set down a precedent and also have cascading effect on examination in either streams for which we are dissuaded to exercise plenary powers under Article 142 of the Constitution. Oh, your lordship, there will be similar candidates like the present petitioner also, who may have applied in that particular point of time. Now that they have become overaged, they may like to again rewind the time to show that by these relaxation notifications, they would have been qualified. How would that not interfere into the executive realm and direct the executive realm to again further relax the age, because when the petitioner is already overaged by now. Now, your lordship, may kindly, this copy, has it been?
Yes.
My lord has this judgment of 2021 SEC online, Punjab and Haryana High Court.
Yes.
I'm just relying on para 30 and 31.
Yes.
My lord has a copy.
Yes.
Para 30 and 31. The petitioners cannot claim extension in the upper age limit by taking the plea of COVID situation. In the present case, it is not the case of the parties that an advertisement in this regard has been initially issued in the year 2019 or 2020, when the petitioners were allegedly within the maximum age limit. In other words, in the present facts and circumstances, the selection process apparently has not been deferred or delayed because of COVID-19 situation. Therefore, the petitioners herein cannot claim the right for extension of upper age limit. Now, this was going on even during the age relaxation period. This was going on. So it was also the process for appointment was going on. If the petitioner was vigilant, he should have been following the process and approached the Honorable Court before it was too late. Now the para 31, your lordship. In addition, this court also finds force in the argument raised by the learned State Council that the petitioners have neither challenged Rule 12.6 of the rules wherein the maximum age limit has been fixed. They have also not challenged the relevant clause of the advertisement where the age has been prescribed as one of the eligibility conditions. The prayer inter alia has been made by the petitioners on the ground that the vacancies came into existence in the years 2017, 18, 19, and 20, but were not advertised, and thus they were deprived of their chances of recruitment. Now, your lordship, if the petitioner had challenged the relaxation policies, which by now is the right to avail that benefit is already over. So if the same was either asked to be reinforced with amendment to further extent or challenged in the prayer, then this Honorable Court's intervention would have been justified. But it is my humble submission that since the petitioner has not taken those steps, now to grant relief under extraordinary circumstance, your lordship may kindly come to 2014 10 SCC page 521. 2014 10 SCC page 521. there are circumstances where the Honorable Court can give exceptional relief. And these are the type of circumstance. Now, paragraph 33.2, which is at page 539. Page 539, paragraph 33.2.
Yes.
33.2. May I read, Your Lordship?
Yes.
Under exceptional circumstances, if the court finds that there is no fault attributable to the candidate, that is, the candidate has pursued his or her legal right expeditiously without any delay, and there is fault only on the part of the authorities, or there is an apparent breach of rules and regulations as well as related principles in the process of grant of admission, which would violate the right to equality and equal treatment to the competent candidates, and the relief of admission can be directed within the time schedule prescribed. Now, this is important, Your Lordship. The relief of admission can be directed within the time schedule prescribed. Here, time is already overaged. It would be completely just and fair to provide exceptional reliefs to the candidate under such circumstance alone, Your Lordship. Now, given the present facts and circumstances of the case, it is my humble submission based on the authorities that I have placed before Your Lordship that as far as the present petition is concerned, the petitioner has no case. That is my humble submission, Your Lordship.
Yes.
My lord, first of all, the petitioner number 5 was not appointed by way of open recruitment. And as such, his appointment, his selection was not published in newspaper. And further, the rejection of my application was not published in newspaper since it is not an open recruitment. Therefore, I had to run up and down the office every day to check. And as soon as I came to know that the respondent number 5 was appointed, then I approached this honorable court. Since this is not an open recruitment, there was no publication in newspaper regarding his appointment, nor the rejection of my application, Your Honor. And now, Your Honor, here in this case, this is a unique and a rare case, Your Honor. The state has issued 2 memorandums, and I'm seeking protection under those 2 memorandums. And as I've cited earlier, that when anybody applies within that relaxation period, or when the scheme was in operation, then that has to be considered, Your Honor. And one more, Your Honor. This, I most humbly pray that this honorable court may kindly note the fact that the irregularities and the illegalities committed by the state respondent, the irregularities and the illegality committed by the state respondent in appointing the respondent number 5, because the very appointment of the respondent number 5 is against the policy of the state government, Your Honor. Therefore, this honorable court may kindly take note of this point also, Your Honor. That is my humble submission, Your Honor.
Yes. Okay. And that's it? Yes.
Bless your Lordship.
Oh.
Lordship, the other day, I was saying the petitioner has submitted his application on 9/7/2021 for a pause. And the relaxation order, as your Lordship is well aware, which was produced by the Department of Personnel and Administrative Reform under the seal of the Chief Secretary, was produced on 16 July 2021. Lordship, may kindly appreciate the system of working of the bureaucracy in this state. Now, once the application has been received by the authority for any job, we bureaucrate at the threshold. And if we find that the person is not qualified, either by age or by educational qualification or any other things, we summarily reject it at threshold. That is what we have done in the case of the petitioner, Your Lordship. So the OM, 16 July
21. We are not aware of that because she has submitted on 9 July 2021. So once we have deduced the application, we find that no, he's overage.
So you
usually
had
many
kept it
people apply-
aside, yes. I got your
Usually, many
point.
people apply, Your Lordship.
Mhm,
Lordship appreciate the difficulty of the state also. Usually, when one post is to be vacated, many people apply. Many people apply. So that way, we have rejected the application of the petitioner at a threshold. Because on reason we find that he was overage. So that is the only thing. That is the only thing. Now, the question of appointment of the private respondent, Your Lordship, we find the private respondent number 5 to be qualified, eligible, and he was more overrated. He was one of the landowners.
Okay.
That is why we have done that. And Lordship may appreciate. Hospital cannot be run without an absence of a attendant. So now we have done that. So, and in the exigency of the public service, we have avoided the private respondent, Your Lordship.
Okay. Yes, I got your point.
That is the only thing. That is the only thing. And so far as the selection process, advertisement has been concerned, Your Lordship, this is a grateful boss, Your Lordship. And the appointment order, Your Lordship, you will find. You'll find in page 25 of the writ petition, Your Lordship. There is a certain criteria that is being given. Criteria is given there. So it was done like in that way. Being a landowner, the private respondent were done in that way. You'll find, Your Lordship, page 25, the appointment order of the private respondent. And there is no procedural lapses, Your Lordship. It was processed in the government as sitting, and it was duly approved by the authority of the state, Your Lordship.
Yes, I've got your point.
So we can say the appointment of the private respondent was a policy decision of the state, Your Lordship.
Okay. Now, appointment policy decision.
We can say. Because there is no infirmity, no procedural lapses. It was open, it was done.
Yes, I've got your
Lordship,
points.
that is my short submission.
My lord, the contention of the learned government advocate is just based on presumption. He has not placed any document on record.
Yes, I think
show
in
the
the
date-
last date also you mentioned that it's all based on
my lord.
presumption.
He has not placed any document on record to show the date when my application was cancelled. That is just his presumption, my lord.
Yes.
That's my humble submission, my lord.
Okay, fine. We'll make it a CAV. Okay, heard Mr. So-and-so, learned counsel for the petitioner, along with Mr. So-and-so, learned senior government advocate for the state respondents, and Mr. 1 to 4, and Mr. So-and-so, learned counsel for respondent number 5.
Yes, lord.
Okay. Having heard the submissions made by both the parties, this matter is reserved for order. Yes.
Obliged, lord.
Not required, not required. Yes? Yeah.
50 who? Who go?